righty, ladies and gentlemen. My name is Jordan Gaither, and I'm here with attorney Lexi Trumble. We're going to be covering the House Settlement Bill and the NCAA, uh, NIL recruitment, the legalities, how that affects high school, college recruiting, and ultimately, I would be quiet and doing more listening and asking questions. So, Attorney Trumbull, can you tell us a bit about yourself, where you're from, and how you got started in this area of law?
Sure. Good morning, Jordan. Thank you so much for having
Good
me for
morning.
this episode. I'm really excited to be here. Like you said, my name is Lexi Trumble. I am a Title IX attorney. I'm an education lawyer. I work at a law firm called Parker Poe in Midtown Atlanta, representing colleges and universities and supporting their athletics departments all across the country. I grew up as a gymnast. I'm from South Carolina. I went to Clemson and competed on their club gymnastics team as an undergrad. And at the same time that I was a student athlete, I did my undergraduate sort of research and thesis on the impacts and some potential causes of sexual and gendered violence on college campuses. Right. And then when I went to law school, I spent the summer interning at a law firm and understanding, right, for the first time that there was one federal law, Title IX, that covers both of those things that I care so deeply about, right? That there is one federal civil rights statute that governs both sexual misconduct, gender based violence, and mandates gender equity in athletics. And so being able to be a Title IX lawyer, right, I have never had to try a divorce case. I've never had to deal with like corporate leasing or with somebody's bankruptcy, right? I get to focus on the things that I care very deeply about. And I'm really excited for the opportunity to practice in Title IX. I think it's a really neat space to be in.
Yes, it's quite intricate, given how technology advances things that we didn't have. Can you speak a little bit about what were some of the hurdles that you started to realize that athletes face when it comes to Title IX and the House Settlement Bill?
Well, I think, right, I was in undergrad. I went to Clemson in 2012, right, which sometimes feels like yesterday and sometimes feels like an entire lifetime ago. And so I think my student athlete experience is very different than the student athlete experience, right? 18 to generally 22-year-olds are facing in 2025, right? But I mean, student athletes have full-time jobs. I think there's a lot of time management, skills development that comes along with being a student athlete. I think there's a lot of, effective prioritization that has to occur when you're a student athlete, particularly at, a Division I institution. I think you have a lot of different commitments. There are people pulling you in a bunch of different directions. And I think for women athletes in particular, right, I think there's a pretty significant knowledge gap. I don't think that a lot of student athletes, male or female, understand the protections that Title IX offers them. I don't think that they understand the obligations that their institutions are under in order to provide an equitable student athlete experience, because they're focused on what time do I need to set my alarm so that I'm at morning lift, so that I can make it to class, so that I can take my exam, so that I can go to practice, so that I can go to study hall and go eat and work out, right? I think there's a bunch of different, uh, right, items that are seeking student athletes' attention. And as the collegiate athletics industry continues to shift and shift very quickly, I'm worried that that knowledge gap will continue to grow, right? I think educating student athletes about their rights, about their institution's obligations, educating athletics administrators about what those obligations look like and how they can go about fulfilling them leaves everybody better off.
Hmm. Can you speak to a specific example as to, I guess if you're going back to yourself in college?
So I think we have, right, I think that question spans a couple of different topics, right? What are some of the major changes, right? What makes a 2012 student athlete categorically different from a 2025 student athlete? Obviously, the advent of NIL, the ability of student athletes at the collegiate level to monetize off of their own name, image, and likeness is something that was not really part of the discussion back in the 2010s, right? That over the course of the pandemic, the NCAA has lifted its restrictions on the ability of student athletes to receive compensation. At that point, it was from third parties and off-campus entities for the use of their NIL. We are now we have entered, we are squarely within the new NIL era, right? And as those restrictions were lifted, student athletes continued to advocate for themselves. They sued under a class action lawsuit that resulted in this new House settlement that went into effect sort of in full force July 1. In addition to that, though, right, I think a debate that we are continuing to have, that various stakeholders are continuing to invest in the college athletics space, is the question of whether student athletes are employees of their institution, right? Are they employees of the particular college or university for which they compete, right? I think my personal crystal ball has been relatively unreliable lately, but if I had to put money on a discussion that will continue and an answer that I think that we need as an industry, it's the student athletes as employees question.
How does the NCAA House Settlement alter recruitment, in particular for younger athletes, given the type of monies that they're now going to be receiving?
Right. Well, to be clear, student athletes are not currently categorized as employees, right? There are several lawsuits. The National Labor Relations Board has weighed in as to whether student athletes are employees. Right? I think some of them very much want to be categorized as employees. They want a steady salary, right? They want a biweekly paycheck. They want benefits. I think a lot of institutions and the NCAA in particular are very against that idea, right? There are concerns about what happens if a student athlete gets injured at that point. Is that a workers' comp claim, right? You have overtime concerns as student athletes, like I said, put in countless hours every week and every month to hone their craft. So at this point, student athletes are not deemed employees, just to level set. But in terms of the House settlement's impact on recruiting, part of that settlement, right, in addition to allowing Division I colleges and universities to pay their student athletes directly for the use of those student athletes' NIL, there is also sort of a restructuring of the number of kids that can compete on any given institution's team at any given time. There are new roster limits that have been imposed as part of this House settlement that apply to Division I institutions that have opted into revenue sharing moving forward, meaning that for some teams, there are going to be more opportunities and more roster spots. Some teams are getting bigger. Some teams are shrinking, right? And so in particular for middle school and high school athletes in sports that are going to see significant roster changes moving forward, they're going to have to do that number crunching, run the calculus themselves to determine their new likelihood of making it to a college team in their given sport, right? If for example, acrobatics and tumbling, right, that roster is expanding. The football roster is shrinking under these new roster caps, right? And so a student athlete is now more likely to be able to gain a roster spot on an acrobatics and tumbling or a stunt team, less likely to be able to clinch a Division I offer for a football program.
Mm. Now, does this mean that there's a potential for a change in recruiting factors and perhaps any negative implications?
Yes, right. I think particularly for D1 schools that are now able to share up to $20.5 million each year with their student athletes, those schools now have a really explicit line item, like monetary stake in those athletes, right? They want them to come to school, they want them to stay at school, they want them to play and to be successful, right? If a walk-on who received no scholarship dollars chose to transfer a year or 2 or 3 years ago, I think a lot of schools might have taken a sort of no harm, no foul approach, right? But now, if they're going to spend a significant portion of their $20.5 million in revenue sharing ability with that football program, they are now cutting checks to a student athlete that now they are much more invested in, and they want to leave even less than they did 2 or 3 years ago, right? And so I think the second part of your question, what are some potential negative consequences for student athletes as we get more financially focused? I think that just like any change, this does have the potential to create some sort of unintended negative consequences. We know that young people who spend a disproportionate amount of time online, as is typically required in order to build a personal brand, to market your own NIL prowess, right? Those young people that spend that significant amount of time online suffer mental health implications, right? Mental health consequences. People's comment sections, especially student athletes whose personal brand is inextricably tied to their performance on the field or the court or the balance beam, those comment sections can be particularly vile, right? And increasing the amount of money that schools themselves are investing in student athletes from a revenue share perspective can also increase the pressure that those student athletes feel to perform well, right? Knowing that you are getting a direct paycheck from essentially your athletics director can add to the layers of pressure that we know that student athletes are already under from any number of different directions.
You mentioned the comment section, mental health, pressure. Are you able to extrapolate on that just a tinge? If not, we got the script here, we can stick to it. But you brought it up and I was just curious. I had to ask.
Yeah, right. I think, we see it in issues related to the NCAA's advocacy to eliminate prop betting from college sports, right? We see it with student athletes who have gained a significant amount of notoriety for their online activities, right? Whether it's their appearance or their athletics prowess, right? I mean, I think if you look at Angel Reese's comment section on any given day, you see a lot of support for the young woman that she is. You also see some really hateful and vitriolic comments. You see them in Livy Dunn's comment section, right? I think people, particularly adults, do not understand that student athletes, even if they are making a gajillion dollars a year, are still young people, right? And I think when you increase the temperature of the spotlight that's on those young people, even as college athletes trend older. Right? We have extended eligibility that come out of the pandemic. Not everybody who is on an institution's roster is between the ages of 18 to 22. Right? Some of them are 23, 24. Some of them might have transferred from somewhere else and regained a year of eligibility. But a lot of them are 18 to 22. And we know that seeing and reading the same or varied hate comments on somebody's online presence have an incredibly negative impact on their mental health, and sometimes has an incredibly negative impact on their physical and athletic performance.
Is there a connection between the Title IX aspect and then some of the issues that student athletes might face?
I mean, I think there definitely can be sort of a gendered component to the hate and vitriol that student athletes see online, right? I think, there is a reason that I named Angel Reese and Livy Dunn as potential, right, hate magnets, right? People love to hate on public figures. People love to hate on women in particular. That's not to say that male student athletes don't experience the same, similar degrees of online bashings. But I do think that parts of that can be a uniquely female, a uniquely women's experience.
Okay. And that was a good segue because my next question is, how does the House settlement affect gender equity?
So I think that question and its reverse, right? How does gender equity impact the House settlement is ultimately the $20.5 million question, right? I think
Okay.
that's something that everybody in the college athletic space is talking about. This new House settlement and the ability of, again, Division I institutions that have opted into this new structure, that ability to share up to $20.5 million annually with student athletes has the significant potential to exacerbate already existing gender disparities, gender inequities across an institution's athletics department, right? I think a lot of people are anticipating that the vast majority of those $20.5 million are going to go to male student athletes, primarily athletes on football and men's basketball rosters. Right? I don't think that is a particularly shocking thing to say. I think a lot of schools have either gone on record already to say this is how we plan to allocate our dollars, and a lot of financial and sports business analysts and journalists and reporters have predicted that that's how a good number of schools are going to divvy out those potential payouts, right? And so I think once you introduce direct and really substantial student athlete payments into the equation, there is a real argument to be made that schools might be discriminating against their student athletes, the female side, by providing a significant portion of that money to male student athletes. I think attorneys, right, plaintiffs' lawyers are certainly making that argument. We've already seen several appeals of the House settlement on Title IX grounds, arguing that at least the back pay damages of the settlement, right? There is a portion that will allow schools to pay student athletes moving forward. There is another key part of the settlement that provides a $2.8 billion pool of money for student athletes who competed over the last 8-ish years that, if not for NCAA rules prohibiting them from monetizing their name, image, and likeness, would have been able to receive these dollars going back several years, right? There is a formula. The parties to that lawsuit brought in an accountant, right, a sports business analyst, somebody who's way above my pay grade, to determine how those $2.8 billion will be paid out. And about 90% of that bucket of money is, in fact, allocated to male student athletes. You've got several groups of female student athletes who have raised their hands and said, the backwards, right, the back damages portion of the settlement is inequitable on gender grounds, on Title IX grounds. And I would not be surprised if, looking at the forward looking, right, the prospective revenue sharing payments, if the same arguments aren't made on that front as well.
Wow. Incredibly knowledgeable.
Thank you.
And I think that everyone watching this will feel that much more confident. When students face these issues of gender inequity, what is their first go-to step that you would recommend based on your experience?
I think the first place that student athletes should go, if they have, right, an inkling or a perception, or they hear something weird that sounds like it might be entirely off base, is talk to your athletics administrators, right? Maybe that's your coach, maybe that's your sports supervisor, maybe it's your SWA, right, your senior woman administrator, maybe it's your SAC, your student athlete advisory committee president, right? Talk to somebody in a leadership position in your athletics department and see whether or not there are any teeth behind what you're experiencing, right? Sometimes we just have a perception issue. There's not an actual inequity or a disparity underlying it, but something just feels off. Sometimes there's what we call an LNJ, a legitimate, non-discriminatory justification for what you perceive to be a difference, right? For example, the chartering of private flights to transport football teams to away games, where the women's golf program, for example, is, riding in a bus or taking private cars to tournaments, right? That is a legitimate, it is a difference. It is an actual difference. It is not necessarily, though, a gender-based disparity, because we can explain it when we consider the logistics that are associated with transporting 120 student athletes, all of their gear and equipment, an entire coaching staff, right, and all of the support staff, student, trainers, and all of the other human beings associated with a football program, right? Sometimes there are legitimate, non-discriminatory reasons for what you might perceive as a difference, and what you might think in your soul is a disparity might in fact just be a difference.
Are there any existing technologies that exist to help people who are managing these compliance matters to make it easier?
Yes, absolutely. Right. There are a lot of third party college athletics business vendors that have automated and have introduced AI and other, right, sort of technology assisted processes to deal with athletics compliance, right? Whether it's calculation of student athlete scholarships, right? That process can be automated because your scholarship numbers, though, athletics administrators are required to be disclosed to the federal government every year. I would really encourage that there is a human person who is double and triple checking those numbers before they're published annually on an EADA, right? An Equity and Athletics Disclosure Act submission, for example. And I'm also finding that some student athletes are using some AI tools, right? Particularly when they have identified something that they feel might be a Title IX disparity.
If there was technology that existed where lawyers manage and are able then to relay to students, so similar to how
It's what Law
students
Pocket does, isn't it?
well, you know, yes, that is what Law Pocket does. And a quick plug, Law Pocket, we synthesize legal information and we refer users to attorneys. We are currently working on a comprehensive work environment that is not utilizing AI to make the decision, but utilizing AI to help the attorney and the student athlete make a decision. And ultimately, in this environment, the attorney is able to manage and make that a lot more of a navigable situation.
It sounds like you got a neat thing going.
Thank you. Are there any unresolved legal issues?
I think the landscape continues to change very, very quickly, right? Just yesterday, President Trump signed an executive order governing, or at least purporting to govern, sort of the NIL landscape in college sports, right? The fallout from that executive order, if any, will be certainly something to keep everybody's eyes on, right? The student athletes as employees discussion is a legal issue that I think we will see come to some sort of a head over the next several years. We've got the SCORE Act currently making its way through our legislative body. There are a lot of, for example, immigration and international student athletes that have questions, and pretty significant and very timely questions about the ability of those student athletes who are here on particular visa categories. Are they eligible to receive these payouts from their colleges or their universities, or will the fact that they are on the same roster even as student athletes who are receiving dollars in exchange, in theory, for their NIL, right? But maybe because they are on a football or a basketball or a lacrosse team, will that jeopardize their immigration status? Will it jeopardize, the allowance or the retraction of their visas, right? As we see, an outsized focus on immigration and an outsized focus on NIL, where I am not seeing a ton of intersection, at least from the decision makers, right? The people with the ability to enact and implement change, is the intersection of immigration and the new NIL ecosystem, right? So I think all of those are new and emerging and very timely issues. But I also think, right, sort of hearkening back to Title IX as a whole, right, NIL is just a portion of Title IX compliance. Title IX covers every aspect of a student athlete's experience. It definitely, right, applies to the provision of NIL dollars and related benefits, right, publicity and students, abilities to market themselves and co-brand with their universities. But Title IX, even taking NIL out of the equation entirely, continues to apply to things like the provision of gear and equipment and supplies, right? Student athletes care a lot about how well outfitted or how poorly outfitted they are. And they're looking across the aisle, your men's teams and your women's teams, to see what everybody else is getting when their gear drops at the beginning of the school year. Title IX continues to apply to things like we talked about earlier, the methods and mechanisms of team travel, right? Scheduling of things like games and practice times, right? Is your men's basketball team always playing at 7 p.m. with the women's team having to tip off at 4 p.m., for example? Right? We're continuing to look at things like athletics facilities. Are football and men's and women's basketball practicing and playing in state of the art, really technologically advanced, gorgeous, aesthetically pleasing facilities, while gymnastics and volleyball and perhaps swimming are practicing and competing in really old, rundown, like mold infested facilities, right? Title IX continues to apply to all of those areas as well. And I would caution athletics administrators in particular to not lose sight of the other portions of the administration of their athletics department that Title IX requires to be done in a way that does not discriminate against male or female student athletes.
How are lawyers and courts preparing themselves or are prepared to handle these matters? As you know, a lot of legal precedent is based upon existing cases or past cases, and it would seem that might be a little difficult and play into how these matters are handled. Am I correct in saying that?
Yeah, Jordan, I think you're 100% correct, right? Title IX was enacted back in 1972, right? At that point, 53 years ago, as of right the date that we're recording this, right, it will have been 53 years ago. The NIL landscape was simply not something that was contemplated by the drafters or the enactors of Title IX, right? It simply was not yet on the horizon. I think right there is a bit of nuance that can be lost when we say that NIL is the Wild West, right? I don't think it is necessarily the Wild West. It is new, but everything was new at one point, right? And I think we as lawyers and the judiciary as a whole have a really neat opportunity right now to make creative arguments to help craft what that new legal precedent is going to look like. I think we do have an area, right? The NIL era is certainly new, but everything in college sports was new at some point, right? And so I think, Title IX being enacted back in 1972 simply didn't contemplate the direct revenue sharing of 2025, right? Neither the drafters of Title IX, nor the framers, nor the enactors, right? None of those people had on their horizon the idea that student athletes would at one point be paid directly by their universities. So I think it gives us as attorneys and the judiciary as a whole a really neat opportunity to craft some really creative and compelling arguments and to help shape what that next layer of legal precedent is going to look like, right? Title IX and its gender equity requirements have been around for long enough that athletics administrators should be comfortable with what Title IX requires, at least in theory. Now the question is just going to be, how does that apply to the new era in which we find ourselves, right? I think we've got several, quite compelling legal battles that are taking place and that will be taking place over the next couple of years that are going to shape the next era of that legal landscape, right? I think the decisions that are made by judges and by the NCAA's president and by other really important and influential stakeholders in the college athletics space over the next couple of years are going to have some pretty significant impacts on what the next generation of student athletes are going to experience when they set foot on campus for the first time come July or August of 2030, for example.
If you have to go to court or just talking to a client, could you speak to the process that you take to advocate for your clients and sort of help them navigate what this issue is?
Yeah, I think there's a lot of document requests that I send out to my athletics administrators, right, to help me understand what that particular athletics department looks like, what's working really, really well for that particular school, what perhaps could be improved, getting a sense and a flavor and a real idea of how that athletics department operates, because they're different school to school, they're different conference to conference, they're different Division 1, Division 2, Division 3, right? I have a really great foundational knowledge of like the letter of the law when it comes to Title IX, but Title IX is going to be implemented differently. Different athletics administrators are going to have different interpretations of and ideas of how or whether or not their particular athletics department complies with all or part or none of Title IX's requirements. And so I think getting a sense of what each individual athletics department looks like, what are their priorities, what are their ideas of culture, and what drives them, helps me to provide what I hope at least is really targeted, really tailored, really practical and pragmatic legal advice to, right, a Division One ACC institution, which is going to look different than, for example, an NAIA school in the Midwest.
Mm. How does that play a factor into judicial discretion that might have to be exercised?
It certainly feels a little bit like we're on sort of shaky ground, right? That everything, the tectonic plates continue to move, right? We're getting executive orders. The NCAA is changing policies, right? We've got a new sort of athletics governing body that's overseeing implementation of the House Settlement, right? The College Sports Commission. Portions of governance and enforcement are being moved out of the NCAA and into the CSC, right? All the while, we have district court and federal courts of appeal judges that are making rulings on things like individual student athletes' eligibility. And, we're going to have some judicial decisions on, the propriety of that $2.8 billion in back damages, right? Whether that formula will hold up to legal scrutiny, right? I think you have several different stakeholders that are exercising varying degrees of influence over the college athletics industry, right? We have coalitions of athletics directors that want one thing. We have the board of directors and other, individuals in power at the NCAA who perhaps want something different. We've got legislators in Congress who are sponsoring or advocating against the SCORE Act, for example. The president has clearly taken an interest in the administration of college sports. We've got a lot of different pipelines of information that at times are saying really different, really contradictory, quite disparate things. And so while some of the ground is incredibly unsteady, right, and I can certainly empathize with people who are consistently getting just bombarded with new information, every piece of which seems to tell you something different and to contradict something that somebody that you trusted told you yesterday. We do still have, at least in some parts of college sports, some guiding principles, right? Title IX is a great example of that. It has been on the books, again, for longer than 50 years now. We understand that come what may, right, regardless of the form that NIL takes or whether student athletes are categorized as employees, that because colleges and universities receive federal financial assistance, right, they receive support from the federal government, that they cannot operate their educational programs or activities, of which college athletics are a part, in a manner that discriminates against somebody based on that person's sex, right? We have some sort of, guiding lights, some lighthouses, some lights in the dark that will, even amidst what I will grant you feels a lot like chaos in college sports. We do have the idea, right, that Title IX requires us to do the right thing, to treat people fairly, to treat our student athletes equitably, to meet people where they are, to give them what they need, and to understand that sometimes that's going to look different for male student athletes than it will for female student athletes, but that ultimately, right, giving everybody the best chance to succeed on and off the field, the court, the balance beam, is an overarching obligation that I think athletics directors and athletics administrators take really seriously.
I think based upon what we've discussed, as always, I believe that you're incredibly knowledgeable. Thank you so much for coming on the show.
I think we've covered a ton of ground. I'm really excited to see what's next for you, right? I'm excited to see what's next for the college sports industry. And Jordan, thank you so much for having me on. I've had a great time chatting with you today.
Thank you so much. This is Jordan Gaither and Lexi Trumble on Keep It Legal, and we look forward to you guys seeing the next episode. Have a great day.